What's up, everybody? Good Saturday morning. Thanks for being here to hang out with me. We are going to go over the first real decision we've had in Karen Read's civil case. And I will tell you, after reading this order, I already like this judge. He didn't take the easy way out. He parsed through every single argument, and I agree with most of what he put in this order. So we're going to break it down. We're going to talk about the claim that was dismissed and why it was dismissed, and whether or not it'll have an effect on what evidence comes in at trial, what discovery is done in the litigation process. Did the defense whittle down the discovery at all by getting one of the claims dismissed, or is it going to be exactly how it was and it doesn't really matter that this one was dismissed? And of course, we are going to answer all of your questions. So let's get to it. So before we get to the order itself, I just want to remind everybody how we got here, because Karen Read did not, and all the defendants, right, CF McCarthy's, etc., they did not file motions to dismiss all of the claims. They didn't even try to dismiss the wrongful death claims. And I'm giving this preface because when we read through this order, the judge is going to explain again how he is taking all of the O'Keefe's claims as true in order to make this decision. And that's been something that's been kind of difficult for people to get past while reading these motions and listening to these hearings and reading the complaint. And I totally get that, because you feel like they've already been proved not true in a criminal court. And we've explained the differences in burdens, the difference in jurisdiction, how it is totally legally appropriate for them to go forward in civil court, even though Karen Read has already won in the criminal court system. But just because they are assumed true for these decisions does not mean a jury will think they are true if and when we get to a civil trial. So when we are discussing this and the judge says, assuming X, Y, and Z is true, I could see how they could get past a motion to dismiss and put this before a jury and have a jury decide. This is a jury question. So that's what the judge's analysis is. And I think he does a really good job of explaining that throughout. But it's a pretty low bar to get past a motion to dismiss, okay? You don't want to lose motions to dismiss in civil court. It is a really low bar, especially when it comes to negligence. So if you do lose it, there's usually a reason why. And to me, there is a very obvious reason why they lost the one claim that they did in this case. So let's take a look at the order together here. Looks blurry on my screen, kind of on StreamYard. So if you guys can't see it, don't worry. As always, I am going to read the entire thing. Memorandum and order on defendant's partial motions to dismiss pursuant to Mass Rule Civil Procedure 12b-6. So that's what partial motions mean. It doesn't mean the motions weren't complete. It means they were not trying to dismiss the entire lawsuit. This matter arises out of January 29, 2022, the death of John O'Keefe. The defendant and moving party, Karen Read, was previously charged with several crimes in connection with JJ's death. So the court is going to call John O'Keefe JJ, which I find interesting, number one. And number two, I assume that means they're going to be allowed to call him JJ throughout the trial. During the pendency of Read's criminal case, which I don't have a problem with, plaintiffs Margaret O'Keefe, John O'Keefe Sr., John O'Keefe's dad, Paul O'Keefe, JJ's brother and PR of JJ's estate, and Kaylee filed this lawsuit asserting claims against Read for wrongful death, negligent and or reckless infliction of emotional distress, and negligent, reckless, and or intentional infliction of emotional distress. Kind of confusing because in Florida, those are completely different claims, but basically seems like some negligent / reckless, and then you also have some intentional. The plaintiffs also asserted claims for wrongful death and negligent infliction of emotional distress against CNC Hospitality, which is McCarthy's, and Waterfall. These defendants are corporate entities that owned bars that allegedly served Read alcohol in the hours leading up to the events at issue. So the court says things like allegedly served alcohol. And while it is just allegations at this point, civilly speaking, he is still going to take them as true when making this decision. So just because he says allegedly here doesn't mean he's going to look at it with a side eye. Reed filed a motion to dismiss all emotional distress claims asserted against her. C.F. McCarthy's and Waterfall joined on Reed's motion to dismiss, similarly seeking to dismiss the emotional distress claims against them. For the foregoing reasons, the defendant's motions are allowed as to the negligent infliction of emotional distress asserted by Kaylee and denied as to Kaylee's claims for reckless and or intentional infliction of emotional distress. The defendant's motions are denied in all other respects. So right off the jump, we hear, what did the defense win? Well, they got booted for negligent infliction of emotional distress as to Kaylee, meaning that Karen Reed did not accidentally cause Kaylee emotional distress. They are not even going to be allowed to argue that. And I completely agree with the judge there. You can't really have it both ways here. In the law, sometimes you are allowed to argue competing arguments or competing thoughts or look at evidence two different ways. Sometimes you're allowed to do that. But here, the main crux of why would they be able to, and you guys can put in the chat or in the comment section why you think they would be able to go forward on intentional infliction of emotional distress against Kaylee, but not negligent. Why do you think that would be? If you remember back to when we read the motions to dismiss, and we say, let's pretend that we're the judge at this point. And as the judge, we are forced to look at this case through the filter of these facts are true. And if these facts are true, and Karen Reed intentionally woke Kaylee up, lied to Kaylee, told her John O'Keefe had passed and he was hit by X, Y, and Z, and then went on this media craze, spreading lies on purpose, and she intended to cause Kaylee emotional stress. She just wanted to do this to hurt Kaylee. She just wanted Kaylee to be miserable. If that's the prism we're looking through, that is true, then how can it also be an accident? And if Kaylee never went to the hospital to see the body for some of these emotional distress claims, how are we really going to work her into some of these? So the intent the intentional element of emotional distress versus negligence has nothing to do with the car accident itself as to whether or not Karen Reed intentionally or accidentally hit John O'Keefe. Okay. So if we're seeing these facts as true. Okay. So regardless of if, they're saying she hit John O'Keefe. So whether it was on purpose or an accident isn't the reason why these emotional distress claims are different as to why the negligent and why the intentional ones have different rulings by the judge. So let's take a read here to the rest of the motion, because there's some very important factors around that may affect the entire way the case is litigated. The following facts are drawn from the plaintiff's complaint and accepted as true for the purposes of this motion. So these facts that the judge is going to make his determination on come straight from the complaint of the plaintiffs. They don't come from the defendant's arguments. They don't come from what the defendant said in court. They don't come from the criminal courthouse. They don't come from the jury saying they believe Karen Reed is factually innocent. None of the facts the judge is considering come from any of those other sources. They come from the plaintiff's complaint. I just had a trial recently where an expert said she didn't read any depots. She didn't read any background on the case. She was making factual assumptions, all based on the plaintiff's complaint, and the plaintiff hired her. And while it works for a judge in a motion to dismiss, it doesn't work for an expert in trial, where you are marrying the facts and the experiments or whatever it is that you do, the research that you do, the testing that you do. It doesn't work because the facts in the complaint are nothing but allegations. You have to use record evidence at trial to tie all of this together. So while it didn't work for that expert, and oh boy, did I have a good time with her on the stand, going through where she got all of her information and the fact that she actually asked the other side for depositions so she could have record evidence And they were like, no, we don't need to give you those for whatever reason. I have my feelings on why they didn't give it to her. But the judge here, that is where he gets his information. On January 28th, Reed patronized C.F. McCarthy's from 8:51 to 10:29. She consumed 7 alcoholic drinks during that time frame. Now, the judge is not going to continue to say, allegedly 7 drinks, or the plaintiff claims 7 drinks. He's just going to say she had 7 drinks. That's a fact I'm taking as true from the plaintiff's complaint. And I'm really trying to drive this home because I know people are going to say, no way, that didn't happen. They already proved it didn't happen, because I'm trying to help us understand why I like this judge and understand how he got here. Then she went to the waterfall, consumed 2 drinks. Her blood draw was at January 29th, and testing revealed her blood alcohol content would have been between a 0.13 and a 0.29 after leaving waterfall. During the time frame relevant to the instant lawsuit, Reed and JJ were in a dating relationship. JJ was with Reed that evening, and they had been arguing. After leaving the waterfall, Reed got into a motor vehicle with JJ and drove to 34 Fairview. After arriving, JJ exited the vehicle. Reed then drove her vehicle and hit JJ. JJ was knocked to the ground, suffering serious injuries that ultimately led to his death. Reed fled the scene and drove to JJ's residence at One Meadows Avenue in Canton. At approximately 4:30 a.m. on January 29th, Reed woke up JJ's niece, Kaylee, who lived with JJ. Reed began discussing JJ's death with Kaylee and talked about striking him with her vehicle. Kaylee heard the defendant say, JJ never came home. Maybe I did something. It's like, if you want to intentionally hurt somebody, do you really say, maybe I did something? Maybe a snowplow hit him. Maybe I had hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. And he's like, I cite this straight from the complaint, people. Reed also called multiple people between 4:30 and 5 a.m. on January 29, 2022, while in Kaylee's presence. At that time, and here is really, really important stuff, what did Karen Reed know? Well, she knew Kaylee was a vulnerable minor who had previously lost both parents and lived with JJ as her surrogate parent. Reed left JJ's residence at approximately 5:07 on January 29th. She arrived at Fairview at 6:03 a.m., discovered JJ buried in the snow. JJ was pronounced dead at the hospital at 7:50 a.m. At relevant times after 7:50 a.m. on January 29th, defendant Reed went to the grieving house of JJ, feigned comfort to JJ's family, and used the opportunity, amongst other things, to remove the offending weapon, her vehicle, or destroy relevant evidence. Subsequently, over the course of several years, here we go, Reed made many public statements. She knowingly and deliberately changed her story and fabricated a conspiracy, knowing the same to be false. She publicly communicated this false narrative, thereby frustrating justice for JJ. Such false narrative caused the plaintiff's aggravated emotional distress. So there's a combination of how Massachusetts extends kind of the zone of danger to a little while after, when you drive and you show up and you see the body at the hospital, which we're going to talk about this. But this section here, that Karen Reed ran in, says this stuff to Kaylee, and then over the next months and years, conspires and concocts this fake story she knows to be false just to frustrate these plaintiffs and cause them emotional distress. That can't be by accident to Kaylee, right? It's not like, oops, I accidentally did this. It's intentional or reckless, I guess, but I don't even see how it's reckless if you intended to do it. Thank you, Tracy, for gifting 5 Lawyer You Know memberships. All right, let's get to the discussion section. The defendants argue that the emotional distress claims should be dismissed for multiple reasons. 1, distress claims are subsumed by wrongful death statute. Number 2, the plaintiff's claims claim distress was not contemporaneous with JJ's allegedly being struck by Reed's vehicle. That's kind of the zone of danger argument. And 3, there was no extreme or outrageous conduct directed towards the plaintiffs that resulted in severe harm. And 4, Kaylee's claims for emotional distress fail as a matter of law. The court will address each of these arguments. The motion to dismiss for failure to state a complaint must contain factual allegations plausibly suggesting, not merely consistent with, an entitlement to relief. The factual allegations must be more than labels and conclusions and raise a right to relief above the speculative level. In assessing a complaint under Rule 12b-6, the court accepts as true the well-pleaded factual allegations in the complaint and draws all reasonable inferences in the claimant's favor, meaning the plaintiff, the O'Keefe's favor. Murder, She Wrote, which is a show I used to watch with my grandmother who's no longer with us, one of my favorite shows and an amazing song. We had just showed it to our kids recently, that show. And then I also was playing the song Murder, She Wrote in my car. And they're like, oh, is this the theme song for that show? I was like, no, it's not. It's very different. Anyways, this case and several others have really opened my eyes to how the cops work hand in hand with the court to get convictions. The truth is irrelevant to them. Their corruption runs too deep. To some of them, not all cops. Ashley said a jury is never going to buy that Karen intentionally hurt her. I tend to agree, but the judge takes it as true at this point. The extent of the court's review generally is limited to the factual allegations in the complaint and any facts contained in attached exhibits. However, the court may also consider matters of public record, items in the record of this case, and documents cited and relied upon in the complaint. Wrongful death statute and emotional distress claims. The defendants argue that plaintiffs' emotional distress claims are subsumed by the wrongful death statute. Among other provisions, the statute identifies the following as recoverable damages: the fair monetary value of the decedent to the persons entitled to receive damages recovered as provided in Section 1, including but not limited to compensation for loss of reasonably expected net income, services, protection, care, assistance, society, companionship, comfort, guidance, counsel, and advice of the decedent to the persons entitled to the damages recovered. So each one of these, we do a lot of explanation to a jury in a trial about what each one of these means. Sometimes we even use experts, but we'll listen to how the court kind of explains how specifically emotional distress fits in with this. I'm losing my voice. I was at a high school football game last night. That's probably why. Nana said, Peter, will the jurors saying they found her innocent play into this? No, they will not. The wrongful death statute contemplates some degree of emotional distress arising from a decedent's death. We can all agree there. It addresses loss of care, assistance, companionship, comfort, guidance, counsel, and advice, all of which go to the relationship between a decedent and individuals pursuing claims under the statute. The defendants argue that the independent emotional distress claims asserted by the plaintiffs are redundant to the plaintiff's wrongful death assertions and consequently should be dismissed. So basically, these emotional distress claims that come with the fact that John O'Keefe is no longer with us, is no longer with the O'Keefe family. That is contemplated. That is protected in the wrongful death statute. But can there be more? Can there be more emotional distress damages than what's contemplated and included in the wrongful death statute? That's the real question for the judge. Nobody's going to argue that the wrongful death statute doesn't cover some emotional distress. It just has to be above and beyond the fact that we know our loved one is gone and no longer with us. The defendants argue that the independent emotional distress claims asserted by the plaintiffs are redundant and that and consequently should be dismissed. The argument is inconsistent with established Massachusetts case law. This case held that the defendant's argument that the plaintiff's claim for emotional distress is preempted by the wrongful death action misconstrues the common law of action for emotional distress. Emotional distress, as the concept has evolved in this Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of a defendant's conduct. A claim for damages based on emotional distress does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this one. Since emotional distress is a wrong to the plaintiff distinct from that done to the decedent, it has to be something distinct. Hitting John O'Keefe and leaving him, as they allege and is taken as true from this judge, cannot be the only thing that also causes the emotional distress claims outside of the wrongful death. In the statutory beneficiaries of the decedent, it is not a duplicative remedy and is not preempted by the wrongful death statute. So this distinction, while legally I agree with the judge, you can see that a judge parses these things very differently than a jury would. And why a lot of lawyers are like, if we can just get past the motion to dismiss, I think I can convince a jury of this. Because some of these distinctions, like the jury in certain cases feels so bad for the victims, so bad for their families, they give them everything. We've actually watched some cases like that, right? Where we're like, I don't know if they're going to win on this, but it's so bad for the defendant that it's going to be kind of, a verdict that just piles on. And that's why these distinctions can be frustrating sometimes for defense attorneys, where they're like, come on, you're really going to allow them to argue this too? And the judge is like, legally, yes. And the way you argue things to a judge and the way you argue things to a jury as a lawyer is very different. And that's why a lot of cases don't settle until after motions to dismiss or motions for summary judgment. They're like, if the judge doesn't kick this, a jury's going to win. A jury's going to give us money on this. We're going to win. They're going to hate your defendant. We're going to prove what they did is wrong. And they're like, well, legally, we think we have this technical argument to get rid of it. And so they won't offer anything until the judge is like, yep, we're going to let them put this in front of a jury. And then they're like, okay, you got us. You got us. Susan asked, how long do you think the civil trial will take? Probably similar to the criminal trial. I mean, it depends, right? Because the defendants are trying to add, 10 new defendants to this case? Multiple months, probably. I would say multiple months. All right, let's keep reading here. Here, the plaintiff's direct emotional distress claims go beyond the mere fact that JJ died. Instead, they point to the alleged wrongs they suffered in their individual capacities. They aver that they suffered such harm in observing JJ after his death, which is, seems different in Massachusetts than a lot of other jurisdictions because they went to the hospital and saw him. Having Reed attend family events in the immediate aftermath of JJ's death, and Reed developing a public and false narrative that frustrated justice for JJ. So this is the one here where, they mentioned Turtle Boy in the complaint and in their arguments that is going to make discovery very, very interesting. These claims are separate from JJ's death and instead are specific to the distress the plaintiffs assert in their individual capacities rather than their status as relatives of JJ pursuant to the wrongful death statute. Therefore, the defendant's motions are denied as to their arguments regarding emotional distress and the wrongful death statute. Next, let's get to negligent infliction of emotional distress. The defendants argue that none of the plaintiffs have actionable claims for negligent infliction of emotional distress because their alleged distress did not occur contemporaneously with the accident giving rise to JJ's death. This argument is inconsistent with established Massachusetts case law. In this case, we held that allegations concerning a parent who sustained substantial physical harm as a result of severe mental distress over some peril or harm to his minor child caused by the defendant's negligence state a claim for relief for which relief might be granted, where the parent either witnesses the accident or soon comes on the scene while the child is still there. 2 years later, we held that the wife of children of an employee allegedly injured through his employer's negligence could maintain an action for negligent infliction of emotional distress, even though they first observed the employee in a hospital immediately after the accident. We said that a plaintiff who rushed onto the accident scene and finds a loved one injured has no greater entitlement to compensation for that shock than a plaintiff who rushes instead to the hospital. So they're showing how they kind of extended this to, you got to see it happen. You've got to arrive on scene quickly. Well, now you just have to go to the hospital after this happened to fit into this. So long as the shock follows closely on the heels of the accident, the two types of injury are equally foreseeable. Interesting. I don't agree with that personally. I think this would potentially open the floodgates to like every wrongful death case. And that's interesting as a plaintiff's PI attorney to not agree with this, but maybe you never think like, especially lawyers, and actually I think this is true looking at the generation ahead of me, when you're told something is true and the way it should be for so long, sometimes it's hard to see it another way. And I've been conditioned to believe that the negligent infliction of emotional distress and intentional infliction of emotional distress should be so one way that whenever I see it a different way, and there may be some legitimate arguments for it, it's hard for me to flip. Like I need some real research that's going to tell me this is how it should be, different from what you have known it to be your entire life. In Florida, this, in my opinion, this would not have held. This would have been thrown out in Florida. But I think Massachusetts is different, and there we go. Chrissy said 4.7K watching and only 958 likes. Everybody's probably tired, right? It's early on a Saturday morning. But now that you've woken up, take a second, click that like button. Thank you. Thus, a family member is entitled to emotional distress damages when they either witness the decedent's actual injury. That's different. That works basically everywhere if you witness the injury, or come upon the injured promptly after the injury. The plaintiffs allege that Reed discovered JJ buried in the snow at 6:03 a.m. He was subsequently pronounced dead at 7:50. The O'Keefe plaintiffs learned of JJ's admission to the hospital immediately and came upon JJ's body. Against this backdrop, the complaint alleges sufficiently that JJ's parents and brother arrived promptly at the hospital, learning about JJ's death, thus have actionable claims for negligent infliction of emotional distress. So this negligent infliction of emotional distress, which again, different between another argument where Kaylee's negligent versus intentional, this negligent infliction of emotional distress can mean that Karen accidentally hit JJ with her car, and that negligence caused this distress because he ends up at the hospital deceased and the plaintiffs see him there. So that is a distinction they're talking about here. Hey, it's me, said, how long till the trial starts? Years, probably. Legitimately, probably years. A normal case like this would take 2 to 4 years. It might be less because of the whole criminal prosecution and litigation. That may cut down some of the discovery. Thank you, Leanna, for gifting One Lawyer You Know membership. Kaylee's negligent infliction of emotional distress claims stand on different footing. And here's where we get into some of the distinctions that are important to this judge and made this judge kind of rule one way on one claim and another on another. She alleges that she learned of JJ's death or injury when defendant Reed woke Kaylee up at 4:30 on January 29th. Further, she alleges she heard defendant say, JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. Lastly, Kaylee states that as a result of Reed's conversations in her presence, she perceived the injuries caused to her guardian, Uncle JJ, and perceived the injury producing event. So just Karen Reed's words. Taken together, the complaint does not allege that Kaylee learned of JJ's death or injury at 4:30 a.m., but instead learned he was maybe injured at that time. How about that? This is one of the reasons I like this judge. He said, listen, I got to take the complaint as true. And what does the complaint say, folks? Maybe. The complaint says maybe. So if you're going to put maybe in your complaint, I'm going to take maybe as true. And therefore, you don't say she actually learned about it, but maybe. There are no averments regarding when the circumstances under which she first observed the deceased JJ. She concerned her perceptions of JJ's injury rather than actual observations. The case law cited by the parties addresses scenarios whereby a family member has observed another family member actually being injured or otherwise suffering shock after promptly encountering the injured family member. Kaylee cannot make this showing. In making this assessment, the court acknowledges the following case law cited in the plaintiff's opposition. The determination whether there should be liability for the injury sustained depends on a number of factors, such as where, when, and how the injury to the third person entered into the consciousness of the claimant, and what degree there was of familial or relationship between the claimant and the third person. Such language is inappropriate here, as the Dzwonkowski court decision turned on liability for negligent infliction of emotional distress and the parameters for when a family member arrived at the scene of an accident giving rise to the relative's injury. Stockdale extended the scope of Dzwonkowski to family members who promptly arrived at the hospital. Neither of these cases, nor any other cases provided by the parties, create authority to find negligent infliction of emotional distress for family members who learn of a death beyond this prompt time frame. I mean, learning of the death verbally gives you a claim for negligent or intentional infliction of emotional distress would just be wild to me. It would just be really, really wild to me. But thus, the language about JJ's injury enter into the consciousness of the claimant does not support Kaylee's claim for negligent infliction of emotional distress. So then how could there possibly be intentional infliction of emotional distress? Wait, there's more. So the defendant's motion is denied as to Margaret, John, and Paul, but allowed as to Kaylee's. So they're throwing out Kaylee's. So does that mean that the whole maybe I hit him, maybe a snowplow hit him, maybe I hit him, is that all out? Is that not going to come in at trial? Now we get to the reckless infliction of emotional distress. The defendants argue that none of the plaintiffs have actionable claims for reckless infliction of emotional distress because there was no extreme or outrageous conduct directed towards them that resulted in severe harm. In the context of such claims, conduct is extreme and outrageous if it goes beyond all possible bounds of decency and is regarded as atrocious and utterly intolerable in a civilized community. Trying to figure out how somebody died, asking questions how this possibly happened, does not go beyond all bounds of decency. Come on. So how do we get here? The standard of extreme and outrageous conduct is a high bar. Such conduct means more than workaday insults, annoyances, and even threats and petty oppressions. It means, for example, a high order of reckless ruthlessness or deliberate malevolence that is simply intolerable. Let's see if we got a couple questions. Give me a break from reading. Peter talks so fast, LOL. I'm still on half a cup of coffee. I'm like, what? I'm a little bit less than half a cup of coffee so far. Shan, has a ruling been made on adding the others? No, not that I've seen. You guys sent me this order. If that one comes out, send it to me. Of course, we will break it down. What's the time frame on emotional distress? If I arrive at the hospital 2 hours later, is that the same as 5 minutes after the person arrived at the hospital? Immediately following or after. What does that mean? Case law parses it out. And every time a judge allows an extended period of time, then the next lawyer is going to push that period of time a little bit further, a little bit further. That's how precedent is made. Deborah Ann said, come on, chat, be nice to each other. This is going to be a long time before an outcome comes in this case. We seriously fighting about something here in the civil case? We're supposed to be civil, guys. Let's be civil, chat. Don't fight. What do you get out of arguing and fighting with somebody in a chat on a YouTube video? Ask questions, explain how you see it, be open to differing opinions, be open to learning and changing your mind, but stand firm on what you believe to be true, right? Bok Grandma. I know that not guilty verdicts cannot directly be used as evidence in the civil trial, but is there an indirect way the defense can use it so the jury knows? The only indirect way it may come out is we are going to hear from law enforcement officers. We're going to hear from the O'Keefes. If it shouldn't come in, and in most scenarios it wouldn't, but in my opinion, because of a lot of the factual scenarios that are going to come out in this case, and The fact that they are saying Karen Read concocted this plan and lied and created a conspiracy, because of that, I don't see how the defense doesn't say, we didn't concoct anything. That was her defense and it was true. And we went to trial and that was our argument. And so maybe they won't say she was not guilty, but I do think there might be ways in this case, which is unusual, that they can make arguments and say things that infer she went to trial on the criminal side and it was not guilty. Deborah, thank you for gifting 5 Lawyer memberships. I mean, look, we got memberships being gifted. What could be better than that? The plaintiffs allege that Read developed a narrative surrounding JJ's death, which caused them to suffer emotional distress. So we are in the reckless infliction of emotional distress. In support of their opposition to the instant motions, they have produced a search warrant affidavit, which is a matter of public record that the court may consider in assessing whether the complaint plausibly suggests an entitlement to relief. According to the search warrant materials, on January 22nd, 2024, Detective Lieutenant Brian Tully, and hey, his name has been mentioned now in multiple documents in this case. Is he inextricably intertwined? Must we add him as a third-party defendant in this case if and when Karen Read sues him? Every time we see his name, it's more and more likely. Of the MSP, applied for a warrant to seize any mobile device capable of communicating and cell phones used by Karen Read. He filed a return of the search warrant on January 24th, 24. Tully submitted an affidavit. Did I get that? Yeah. Tully submitted an affidavit in support of the search warrant application. The affidavit comprises 31 pages and discusses Read's communications regarding JJ's death. Briefly stated, the affidavit largely describes actions by a local blogger, Aidan Kearney, who runs a series of social media websites under the name Turtle Boy. Another name that has made its way into multiple court documents, which when we talk about discovery in this case, he's going to be all over it. It is going to be widespread. And this is why they even have a semblance of an argument to get all these 10 defendants added. In a normal case, no way, no how, would never happen. But here, it's just different, so it seems. Joanne, Peter, also Kylie has been hearing this. Kaylee, I believe, is who you're talking about, the niece, has been hearing this from her relatives for years and years. So who's to believe that she's actually remembers all of that, or she's hearing it from her grandparents and others? So Joanne, this is actually not a novel concept in these kind of cases, especially with minors. You can imagine in certain abuse cases, minors are told things happened where sometimes it's deplorable and horrible and true that it actually happened. Sometimes it's not true, but they're told it enough. Somebody wants to get custody or somebody hates the other person and, concocts this story. And now they believe it is true. And there's all sorts of psychiatrists and psychologists that study this and testify about certain beliefs that can really stick in your brain as true that might not be. Maybe or maybe not. That might become a thing in this case. I don't know. Sleepy Ash, thank you for gifting 5 Lawyer memberships. The affidavit states that Kearney posted articles on social media accounts that reflected personal attacks on civilian witnesses, members of their families, and their friends. The affidavit also states that throughout various postings and videos, Kearney identifies several individuals who socialized with JJ and Read, stated that they, not Read, were responsible for JJ's M, and encouraged his social media followers to contact and harass these individuals. Additionally, the affidavit references certain comments Kearney directed to the O'Keefe family. How much slack are we supposed to give you, John O'Keefe's family, the time period for the grief, whatever, that we are giving you? Like, we are not going after you because of the grief that is expired. It's expired because you're trying to send an innocent woman to jail for the rest of her life. I don't feel bad for you anymore. Oh, okay. So we are going to get, the discovery in this case is going to be crazy. And allegations like this, it does open the floodgates to so much discovery that is going to be discovery in Karen Read's case where she is the plaintiff, where she's trying to add those defendants. This is going to be an interesting test on, it's not always what you say, but how you say it. Because being mad that an innocent woman might go to jail is true. saying that is perfectly appropriate. But how you say it, who you direct it to, not caring about the grief of a family who lost a loved one, is that going to rise to the level of extreme and outrageous? Is Aidan Carney an agent of Karen Read when he's saying these things? What are the phone downloads going to show about say this or put this out there, or just having conversations with somebody that was a friend and then them taking those conversations and running with it? A lot of that is going to be parsed out potentially in this case. Per the affidavit, Read communicated with Carney through an intermediary, Natalie Wickwicki Berksnyder. Through this intermediary, Read gave Carney information concerning her case, some of which was potentially not available to the public, which Carney then used in his social media postings. Read also shared personal information and pictures of many civilian individuals for whom Carney argued were responsible for JJ's death. When applying the plausibility standard required by Rule 12b-6, such actions are consistent with the plaintiff's averments that Read developed a narrative surrounding JJ's death. Carney unquestionably took extensive efforts in publicizing information regarding the charges against Read, and the affidavit describes Read acting in concert with some of these efforts. Some of these efforts. You cannot, applying all of what Aidan Carney did to Karen Read as her agent would be wild, unless there is something that says, do this, Turtle Boy. Because you can tell somebody something and not know what they're going to do with it and not actually direct their steps and actions. It's a dangerous situation here. Notably, Carney stated that the time had expired for quote unquote going after the O'Keefe family. And again, that's like the language of how you say it. What do you mean go after the victims' families? Like, that's wild. And that the O'Keefe family was involved in a cover-up regarding JJ's death. And again, this is where if you go all the way back to the first case and it's like, how many people are actually involved in this conspiracy and cover-up? Is it really everybody? Why would the O'Keefe family want to do this? Why wouldn't they want to? It never made sense. It makes sense to me that they trusted their friends in law enforcement, and this is what they said happened, and they trusted the investigation. That's totally plausible. The vast majority of victims' families do that. But to think that they intentionally covered up and were in on this conspiracy, that's where you get into trouble. Taken as a whole and implying the plausibility standard, the complaint and this warrant affidavit set forth sufficient facts that the extensive media attention perpetuated after JJ's death caused the plaintiffs to suffer emotional distress. So the recklessness was in what they did, right? And if it was a lie, and if it was done just to hurt the O'Keefes, and if it was targeting the O'Keefes, and it's taken as true, let's not forget the context. I tried so hard to make sure everybody understood the umbrella of how we're looking at this motion. If you take all that as true, he's saying, yes, I do find this to be extreme and outrageous. And I think to say the cops covered it up, or the people inside 34 Fairview, they actually did this, and the O'Keefes, you're getting duped, to say something like that may have been seen as not extreme and outrageous. But to go after the O'Keefes directly, this judge finds that it passes the bar at this point. Primarily, the defendant's motion set forth generalized legal statements for extreme and outrageous conduct. As to a substantive argument, Read cites to this case. It's arguably similar because it dealt with 1, filing false police reports and harassment prevention petitions against the plaintiffs, 2, verbally attacking the plaintiffs, and 3, monitoring and recording the plaintiff's home on a continuous basis. The SJC in Pole held that such action did not rise to the level of extreme and outrageous conduct. The court acknowledges that Pole shares parallels as to a dispute between individuals which escalated into an allegedly harassing behaviors. However, given the extensive scope of media scrutiny and Reed's relationship to Carney, so I would like to know what the judge believes Reed's relationship with Carney to be. As alleged in the complaint and search warrant affidavit, that he was her agent, I guess, the facts of this case rise above those at issue in Polle because of their public and pervasive nature. Public and pervasive nature. I don't know that I love this. This might be the part that I have issue with the judge. I said I agree with almost all of what he put in here, but I think some inferences are being made, like he's jumping more than just taking the facts in the complaint to find that this is extreme and outrageous. But I can't say I'm surprised. And the reason I can't say I'm surprised is I'm trying to put my logical, even-handed hat on. But when you hear some of the videos and things that are said, you read some of the articles, you read some of the posts, I don't think it's so hard to find some of what Turtle Boy said in these videos as extreme and outrageous. I probably would define it that way myself. Just generally as a layperson, it would shock the system of your average citizen, my opinion. And a lot of what he said has come out to be true. And that's why it's not always what you say, but how you say it. And I've been saying that from the jump, right? But the agency between Karen and Turtle Boy, that's an interesting one for me. That's an interesting one. Therefore, the defendant's motions are denied as to their arguments regarding extreme and outrageous conduct. All right, before we get to the last section, let's answer some questions. Richard, can the defense call one of the jurors to explain why they believe she is innocent, and if anything, after the trial change their mind? No. Nope. That is not something that is appropriate or admissible or relevant to the civil trial. So that will not be allowed. Chance said, can jurors from the criminal trial be called as witnesses? No. So it's funny. A lot of you guys had the same thought and comment. No. Peter, during jury selection, if jurors knew about Karen Reed's criminal case verdict, would they be struck? Is there ever a change of venue in a civil trial? I guess you could probably ask for a change of venue in a civil trial. I don't think it would work. I've never heard of that happening. It's a really good question, Azam. They can be struck. So if they have heard about the criminal case verdict, it depends on if the sides want them to be struck for that. If the judge says, can you be fair and impartial? I think if either side wanted them to be struck, that they would be struck for cause. So yes, I think they could, and most likely would not end up on the jury if they knew about the criminal case verdict. So then why aren't they suing Turtle Boy? If the judge is allowing this to go forward under these theories, I think they could. I think they absolutely could. He's basically saying Turtle Boy's conduct was extreme and outrageous. That's basically what the judge is saying here. If the allegation, let's not forget, I'm going to keep saying it. If the allegations in the complaint are true, taking them as true, I think he would have granted or denied a Turtle Boy motion to dismiss these same claims. And I think they would have been allowed to go forward based on this order. So I don't know why they chose not to sue Turtle Boy. All right, claims. I don't think he needs any more lawsuits to deal with. Maybe they're waiting for some of the criminal stuff to be finished with him or whatever. But I think that your First Amendment right is really important. And there are different people that see certain things as abuse and not. I am going to fall far in the direction of liberally construing the First Amendment and allowing people to say things I disagree with and things I would never say and things that may shock my system. I still feel like people should be allowed to say it. But based on this, the allegations in the complaint, if taken as true, to target and blame and harass the victim's family, the judge is saying he finds that is enough to clear the bar to at least allow it to go past the motion to dismiss. And again, him saying that doesn't mean that Turtle Boy should be thrown in jail for what he has said. Let's make that clear. This judge allowing this cause of action to go forward does not mean that this judge believes Turtle Boy should go to jail for what he said, right? Very important, the nuance here of what's actionable, what's a fireable offense, what's a jailable offense or a criminal offense. I mean, all of that is different. All right. Claims asserted by Kaylee. So here we go. Now let's get into some more of the interesting legal nuance. The defendants argue that the complaint does not assert sufficient facts that Kaylee suffered emotional distress and that it does not describe which conduct applies to which claim. As discussed above, Kaylee's claim for negligent infliction of emotional distress must be dismissed for failure to state a viable claim. By the way, I should have mentioned this. I believe, I didn't see with or without prejudice, but I believe that they can refile with more facts and try to go forward on a negligent infliction of emotional distress claim for Kaylee. Because I believe this was dismissed without prejudice and they can amend their complaint. However, consistent with Margaret, John, and Paul's claims, Kaylee was also plausibly distressed by the public and pervasive nature of Reed's alleged false narrative. The alleged facts surrounding Kaylee's interaction with Reed in the early morning hours on January 29th of 22 can also be plausibly characterized as extreme and outrageous. Such determination supports Kaylee's claim for reckless infliction of emotional distress. Kaylee is the only plaintiff who asserts a claim for intentional infliction of emotional distress. So this can no longer be accidental action by Karen Reed or reckless. So accidental would be negligent. Reckless would be if you see Turtle Boy or other people running with this narrative and you keep giving them information, that is reckless of you, Karen Reed, to do that, and therefore reckless infliction of emotional distress. But it still might not be intentional if you didn't say, go out and do this. So how do we get to intentional? You're seeing the levels: negligent, reckless, intentional. A claim for intentional infliction of emotional distress requires sufficient averments that Reed intended to inflict emotional distress, or that she knew or should have known that emotional distress was likely the result of her conduct. With reference to the specific allegations of the complaint, Reed's motion states defendants questioning what happened during a phone call with third parties, even if in Kaylee's presence, is also not actionable. This does not cover the full scope of what occurred during the early morning hours of January 29th in the manner alleged in the complaint. Instead, the complaint plausibly pleads that Reed made multiple distressing calls about JJ's physical condition, namely being struck by Reed's vehicle or by a snowplow. Moreover, Reed made these statements upon waking Kaylee up at 4:30 a.m., which plausibly contributed to the distressing nature of that interaction. Even if this court were to accept Reed's position that she was merely engaging in telephone conversations. So here's another little nuance I disagree with the court on. Because the court didn't need to do this, but he did. He said, even if this court were to accept Reed's position, in my view, if you accept Reed's position, this does not and cannot get past a motion to dismiss. It just can't. Even if this court were to accept Reed's position that she was merely engaging in telephone conversations, conduct otherwise reasonable may become tortious when directed at an individual known to be particularly susceptible to infliction of emotional stress. I think that's fair. At the time of this interaction, it can be inferred that Reed knew Kaylee was a vulnerable minor who previously lost both parents and lived with JJ as her surrogate parent. Given such status, Kaylee would be particularly vulnerable to distress caused by an additional loss of a parental figure. I agree with all of that she could be particularly susceptible to emotional distress. But having a phone conversation right after you wake up and realize your boyfriend is not there and try to figure out what happened, we are going to say that rises to the level of intentionally inflicting emotional distress? So while I agree with the judge that based on what's in the complaint, if we take those allegations as true, I think that this gets past the motion to dismiss on the intentional infliction of emotional distress for Kaylee. I get that. She got up. She's waking Kaylee up, frantically saying this stuff that in the complaint, she knows to be false, right? Because she created this false narrative. So if she knows it to be false and wakes up Kaylee and does this, I can understand how the intentional infliction of emotional stress goes forward. If she intended to harm Kaylee and make up these lies and say things she knew to not be true, fine. If all that's true, sure, she can go forward on this claim. Like Ashley said earlier, I think there's almost no way they ever prove that. But if they do, I understand how the intentional infliction of emotional stress goes forward. But to say, even taking care, even, assuming Karen Read's arguments, it's like, no. If you assume Karen Read's arguments, they lose. So he doesn't need to do that. And he made it very clear in the hearing that he doesn't need to do that, yet he did a little bit of it here. I don't know why. Here's why I think. This judge is trying to be fair and even-handed. This judge is trying to consider everything. This judge is well-researched, well-mannered. I think this is going to be an excellent judge for this case of trial. Hopefully I don't come back to eat my words, but I'm optimistic on how he's going to handle this case. Wiggle. So if Jen M was deposed for the civil trial, can she be purged on previous testimony in the criminal trial if the criminal trial isn't allowed in? No. Just like you heard in the other case, a previous statement you gave under oath. So they're not going to say the criminal trial, you said this. They're going to say in a previous under oath statement, you said this, and they're going to absolutely be able to impeach her. Absolutely. Kind of disoriented seeing court name J.O., J.J., see so many courtrooms where lawyers are admonished that at least parties may only be referred to by full name or title and last name. Have you ever seen this before? Absolutely. I've seen this a million times where they go by a nickname like JJ. JJ is fine. Sweetie Pie might not be allowed, right? Like you can't give a nickname or some derogatory nickname. Usually those are not allowed. And sometimes first names are not allowed, especially in criminal trials. So it is different here and there, but a million times I've seen a nickname like JJ. Think about it, or AJ. It's like JJ is John Jr. It's not something crazy. Like it all depends on what the nickname is as to how judges are being willing to use it. And if neither side objects, it's not going to be a problem. And calling somebody Maggie or Jenny, if you're trying to, garner sympathy versus JJ, maybe people are saying he is trying to garner sympathy with JJ. And if they had a good argument for him trying to garner sympathy with that, I think they'd have a good argument where the judge would say, no, call him Mr. O'Keefe. But when you're calling him Mr. O'Keefe and you have 3 Mr. O'Keefes in this case, that can also be confusing. So we are allowed to differentiate between different parties in the case, especially when there's a family affair here. Are there any mods, people being ugly this morning? Yes, there are. People are always going to have different lines on where they think things are. So I understand we do the best that we can and what we think is appropriate. And we also try to encourage everybody to be kind and disagree appropriately and respectfully. Could Dever sue the Boston PD or the state? She resigned. She wasn't fired, so that makes it more difficult. Chance, Turtle Boy has recently said that he and Karen Read are not friends and will never be friends. Oh boy. He states he supported someone he saw as being framed by LE and liking Karen had nothing to do with it. Respect for that. I respect him for that, honestly. That's how I feel. Like that's how I feel about lots of things. Like, I don't care if I like people or if people like me. Maybe Turtle Boy, for an example, people have said he said stuff about me in the past. I still think he's presumed innocent. I hope his lawyers do a great job. I really like Mark Betterow, his lawyer. I think he's got great lawyers. I want his First Amendment right to be protected like everybody else's, regardless of what he says about me, right? And some people have said he said really nice things about me. And guess what? If he said really nice things about me, that's great. Also doesn't change the way I look at his scenario or Karen Read. If Karen Read didn't like me, I would still feel the same way about that. So I respect that take from him, assuming it's true. It's hard for me on the internet to assume anything's true these days, right? So I don't know that he said that, but if he said that, that's exactly how it should look. Truth or conspiracy? Well, that's where I think it's going to come down to a factual argument for the jury. And if I'm the defense, I'm like, Judge, we're going to prove this is true. And by proving it's true, we need all these defendants here. So if they're saying this conspiracy is how they have the emotional distress claims, which they don't need for wrongful death, so is this really worth it? And that's what I wanted to eventually get to is, how is this going to affect the discovery? Not that much. Just getting rid of one negligent infliction of emotional distress claim is not going to affect the discovery that much. So with this wide open discovery on Turtle Boy, the conspiracy, the publicity, what Karen Read did or didn't say. You're opening Pandora's box. Maybe you're opening Turtle Boy's box here. I don't think that's a box you want to open. Idiot win. Follow up, I guess. If naming thing has happened in a trial of yours and you felt it may serve the other side a little, would you bring it up in court? 100%. Anything that would help my case this much, I'm going to bring up and try to do for my client. When I say my case, my client's case. You fight for every inch. It's like the Any Given Sunday Al Pacino speech, every inch. I'm guessing it depends. So let's say this case. Oh, if I felt like this was helping them, I would bring it up and fight about it pre-trial. Absolutely. But if they have legitimate arguments, I would bring alternatives. Like if one of their arguments is there's so many Mr. O'Keefes, how can we disagree? I'd have to come up with an alternative. Leanna, welcome to the crew. All right. Thus, based on Kaylee's vulnerability and susceptibility, Read, at a minimum, knew or should have known that her conduct would cause Kaylee to suffer emotional distress. This plausibly, and by the way, the judge saying this plausibly and putting in that kind of language almost infers to me he knows this is going to be an uphill battle for a jury, but plausibly supports a claim for intentional infliction of emotional distress. Therefore, the defendant's motion to dismiss are denied as to their arguments regarding the sufficiency of Kaylee's claims. So this is letting everybody know the very low bar to get past a motion to dismiss here. Wherefore, the defendant's motions are allowed as to the negligent infliction of emotional distress claim asserted by Kaylee and denied as to their claims for reckless and or intentional infliction of emotional distress. The defendant's motions are denied in all other respects. Daniel O'Shea. A good Irish boy. Can we assume that? Okay. So a lot happening there. A lot to get through. To me, I think that this is a well-researched and legal reasoned order by this judge. So I look forward to see how he presides over this case. I appreciate you guys so much for joining me on a Saturday morning. I know everybody's got a lot to do. Go Florida State tonight. Please beat the U. It's rivalry weekend. We need it after last week. I appreciate everybody here joining me. Keep a lookout for the podcast on Monday. Brand new trial coming October 20th. Brian Walsh's trial. Me and a special guest take a look, and he's going to be joining me throughout the trial to do weekly breakdowns. So if you want his take on it, all things Brian Walsh, make sure you show up 8 a.m. Monday morning. Hit that like button when you get there. Hit the like button here on your way out. You guys are the best. I appreciate you so much. Make sure you are subscribed. Double check it if you haven't checked lately, because YouTube unsubscribes people at random times. I appreciate you guys so much. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.